So I'd like to call this regular meeting of the Lane County Board of Commissioners back to order for Tuesday, May 22nd, 2018. And we are to item 13A on our agenda, which is a Public Works item, public hearing for Order 1805-2206 in the matter of surrender of a portion of Coast Guard Station Road, sorry, I almost did that wrong, Coast Guard Station Road, County Road number 65, and a portion of South Harbor Vista Drive, County Road number 1301, to the City of Florence. And we have Jay Baume, our county surveyor here. So, Jay, do you have an initial report before I open the public hearing?
Yeah, I just have some brief comments. Good afternoon, Commissioners. Like you said, we're here today to conduct a public hearing on the matter of surrendering jurisdiction of South Harbor Vista Drive and Coast Guard Station Road to the City of Florence. ORS Chapter 373 requires that a public hearing be held to allow testimony to be entered into the public record. The City of Florence, by its Resolution Number 2, Series 2018, has formally requested that jurisdiction of both aforementioned roads be transferred to the City of Florence. ORS Chapter 373 provides for the transfer over county roads within a city when it is considered necessary, expedient, or in the best interest of the county to do so. Both roads proposed to be transferred are located entirely within the city limits of Florence and consists of a total of 0.19 miles of right-of-way. ORS Chapter 373 requires that legal notice of the public hearing be posted or published. Legal notice was posted as witnessed by the affidavit of posting marked as Exhibit D to this order. Lane County staff recommends that the board approve this jurisdictional transfer to the City of Florence. Approving this order will relieve Lane County road maintenance from future maintenance obligations along both roads. At this time, I'd like to turn this back over to you to start the public hearing.
Great. Any questions of staff before I open the public hearing? Then I'll open the public hearing on this item. Is there anyone signed up for the public hearing? Is there anyone here that wishes to speak on this matter? I will close the public hearing. The formality is done. Any discussion to the board or motion? Commissioner Lyken.
Thank you, Mr. Chair. So I'd like to move approval of Order 1805-2206 in the matter of surrender of a portion of Coast Guard Station Road, County Road number 65, and a portion of South Harbor Vista Drive, County Road number 1301 to the City of Florence.
Second.
Been moved by Commissioner Lyken, seconded by Commissioner Farr. Any discussion of the motion? Seeing and hearing none. All those in favor, please say aye.
Aye.
Aye. Any opposed? Motion passes unanimously. Thank you, Jay.
Thank you.
And with that, we'll move to item 13B, which is the fourth reading and deliberations of Ordinance 1802 in the matter of amending Lane Code Chapter 14 to add, revise, and delete definitions and provisions to modernize and update the entire chapter, and amending Lane Code Chapters 10, 13, and 16 to update references and definitions and provisions for consistency with Lane Code Chapter 14, and adopting Savings and Severability Clause, file number 509PA 1605492. And we have Amber Bell and Company. So.
Thank you, Chair. Good afternoon, Commissioners. Today we're requesting that the board approve a fourth reading and set a fifth reading and conduct deliberations on Ordinance 1802. As you may recall, the board conducted a third reading and public hearing on April 10th. The hearing was closed at that time, and the board held the written record open through 4 p.m. on April 24th. Comments received through April 24th and staff analysis of those comments have been put in your packet that's before you today. Just to touch on a few items, there's at least a few comments that were submitted regarding the ability for applicants to obtain additional one-year timeline extensions after the initial 4-year approval period and initial 2-year timeline extension for certain resource dwellings. Prior to 2001, the statute was clear that the approval period was 2 years initially, and then there was an additional 1-year timeline extension allowed, provided that the criteria haven't changed. And then in 2001, with Senate Bill 724, that extended the approval period to 4 years with an extension period of 2 years. And it doesn't appear that the rules or statute explicitly prohibit 1-year timeline extensions. And as promised, we did listen to audio recordings of both the House and Senate committee discussions on Senate Bill 724. And after listening to those, it didn't seem that any of those discussions were specifically geared at limiting the additional 1-year timeline extensions. So it does appear that to staff that the additional 1-year timeline extensions are not prohibited by state law. Another issue raised in comments has to do with the revocation of a decision made in error. Various comments were submitted regarding that language. Mr. Close's April 10th comments provided some suggestions to this code language, recommending that it not apply to final land use decisions except if the application was fraudulent. This is ultimately a policy call that the board can make. Staff have made a couple of recommendations in addition to Bill Close's recommendation in the board packet. That is, staff would suggest that the director, this be a consideration, not a must requirement, and also that revocation when a decision has been made in error, that can still be made within an initial approval period. So that language is in your board packet. If the board would like to adopt this language and incorporate this into the draft code amendments, then you could do so by reading that into a motion. House Bill 424 was discovered after the after the third reading and continued public hearing. That went into effect on April 13th, 2018, and it basically allows a hearings official to review a LUBA remand, provided that the local governing body takes one of 3 actions, being that the board either adopts the decision on consent, leaves the hearings official's decision as the final county decision, or holds a hearing. And so the draft before you has been revised to include that provision, and it includes all 3 options. Staff have distributed a memo to the board today with some additional amendments to Lane Code 14080, the appeals processes. So the idea with these amendments is often we receive appeal statements that are lacking in specificity, and so when we take the appeal to the hearings official, staff have not been able to prepare a staff report that fully responds to the appeal issues, and we need to request additional time or either continued hearing or to hold the record open to respond to the issues. And so the language before you specifies that there are certain appeal requirements, one of which is that the appeal must include a statement explaining the issues being raised in the appeal, have sufficient specificity to afford the approval authority the opportunity to resolve each issue raised. One of a revision that was made at the April 10th continued hearing are that these requirements of this section are jurisdictional. So that would be somewhat of a policy change from our current code, in that an appeal could be rejected if it didn't meet all of the requirements for a content of notice of appeal. And then the third revision is clarifying that because these requirements are jurisdictional, and we've specified that the appeal content requirements do need to be met for an appeal to be accepted, that similarly, an appeal could be rejected if it didn't meet all of the appeal requirements. And so if the board would like to make these changes, we would recommend that the board make a motion to fold that into the ordinance as well. Since staff have made some revisions to the draft based on public comments, we believe that a 5th reading is required. And additionally, because we have proposed some changes to the draft based on things that are not responsive to public testimony, like the House Bill 4124, we would recommend that the board reopen the written record for at least a week. And we're recommending that 1 week written record period with a 5th reading on June 19th. And that concludes my presentation.
Pete, go ahead.
I previously sent an email to Ms. Kay, and then I followed it up with emails to Mr. Hurley and Ms. Wright, Ms. Eichner, and now Ms. Bell. Incorrectly, the first Ms. Bell, but now secondly, the correct Ms. Bell. And that's on the topic of I guess I'll call it a potential conflict of interest, that Sean Malone's a lawyer and he represents on some issues Land Watch Lane County. Well, I'm a lawyer and I have a small part-time law business, and Mr. Malone and I are working together on a case. So we never talk about land use issues. And I wanted to, first of all, get that on the record here in case there was anything that Mr. Malone had submitted. Did he submit anything in this case?
He had submitted some comments. But
Okay, so then that's appropriate for this hearing, just to put that out on the record. But I haven't had any contact with him on the topic of the ordinance. And so I wanted to ask Mr. Clark, where there's a disclosure of ex parte contacts in the ordinance, where it says any member of a hearing authority for a quasi-judicial application. Now, this isn't quasi-judicial, so I guess it doesn't apply here, first of all. But if in the future we enact this ordinance and then we have quasi-judicial hearings like we have all the time, then it says, a member of the hearing authority must reasonably attempt to avoid ex parte contact. Now, we've had a lot of instances where the commissioners, particularly the East and West Lane District commissioners, they have constituents that come to them and say, hey, what about this gravel pit? And they start asking for meetings. What does that first phrase mean, reasonably attempt? Because they often will hold meetings in their districts because people want them to have meetings. Do they tell them, no, I'm sorry, I can't do that because there's a code that says I can't, I would be reasonably attempting to set up a meeting with you to reasonably discuss your reasonable concerns, and that appears to violate the first part of that.
Yeah, I generally think that's correct, that commissioners need to be aware of the responsibilities and the limitations on meeting with constituents on quasi-judicial matters. Extends frankly beyond the land use context. It's in our piece of the land use code, but it's not limited there. Wherever you're making quasi-judicial decisions, it's applicable. And what the individual board member needs to do is note that to the constituent. I can't meet with you because, or if you receive mail, email, that sort of thing, to return it to them or reply saying, I haven't read this because it's that the first bit I read seems to touch on an issue that's going to be before me in a quasi-judicial capacity, and I can't meet with you or talk with you about it. And so, yeah, there's that obligation is there on each individual commissioner as well as it's on the hearings officials who are hearing these matters.
Now, it says, as used in this section, ex parte contact is communication directly or indirectly with any party or their representative outside of the hearing in connection with any issue involved in a pending hearing. So in my example, where I'm doing business with Mr. Malone, but I haven't had any contact with him on this issue, would that qualify as ex parte contact? Or would that qualify as not ex parte contact?
Well, it has to be on the subject that's germane to the matter. I think the lawyer obligations, frankly, are to the extent that you're, the sort of Chinese wall rule, if you're in a firm together, to the extent that your association with the attorney.
We're not in the same law firm yet.
So to the extent that your association together on some matter is similar to that, you just need to be clear between the both of you that those matters won't be touched on.
And part of my own disclosure has been, I don't know if I did it today or not, but that this work I'm doing with Sean Malone, it has to do with a another court far away. It doesn't have anything to do with Oregon land use law, and it doesn't have anything to do with Lane County. So it's like completely, totally separate. Are there any changes in Section 5 on the disclosure of ex parte contacts? In other words, I don't want to read the whole thing, but,
I don't think any additional changes were made to that
okay.
section, no. I think it's probably important whenever you make a disclosure, for example, when the individual board members note that they've had an ex parte contact with a constituent or somebody involved in it, to note that to put the contact on the record when it's appropriate, and also to note at the end of that the contact won't affect their decision-making role.
To state whether they are capable of rendering a fair and impartial decision.
Exactly.
Yeah. Okay. Good. Now, I guess under the circumstances I've given about my own potential conflict of interest, you'd probably say there wasn't a conflict of interest on the facts that I've given.
Correct.
Yeah. Would that be a ex parte contact, though?
I don't think it would be in this context because it's mostly legislative matters
Yeah.
that we're dealing with here.
Yeah, because this is legislative.
Yeah, and in that context, yeah, constituents can contact commissioners and say, here's why you should or shouldn't
Yeah.
adopt this piece of legislation.
Yeah.
So, yeah.
Okay. Thank you so much.
So I have a couple questions real quick. On the revocation issue for error, what is the initial approval period? In this particular language you're suggesting, if we were to adopt about, acceptance situations that shown to involve fraud on the part of the applicant, or when the final land use decision is still within its initial approval period. I didn't know that's a defined, what's the initial approval period? Is that within the appeal period? Is that what that's referring to?
We're talking about the statutory decision.
I believe what you're referring to is the language that we're recommending in the board packet.
Yeah.
So what that's in reference to is specific permits have specific approval periods. So for certain resource dwellings, it's a 4-year period that you would need to complete development within. Most permits are a 2-year approval period that development must be completed within.
So with a forest dwelling, it's got the 4-year period. I get approval for that. I get out there and get my house constructed in that first year. We can still come back as the county and revoke that permit 2 years later for a cause other than fraud?
In theory, the way that language is proposed, yes. I mean, the idea behind it is with the addition of within the initial approval period is to put some time stamp on it, almost like a statute of limitations, if you will. So it's not 10 years down the line that an
Right.
applicant would have that uncertainty.
And
And it could be a shorter
Yeah,
amount of time.
Yeah, I think the issue that Mr. Close brought up and the issue I'm greatly concerned about is we might have made an error in our process, but 6 months after that error, people can have hundreds of thousands of dollars invested in the approval of that permit, if not millions, depending on what the permit's for. And our ability to go back and just say, oh, oops, we made an error, we're going to yank that permit now, makes me really nervous. And I, of course, if somebody, used fraud to get the permit in the first place, that's a completely different story. Then they were, investing that money based on something they committed fraud in the first place to do. But if it was an error on our part to approve a permit, they were going under the good intentions of that they got the permit legally and may have made, huge investments. I mean, you're talking about people's dwellings and all that. Usually it's their largest investment and largest asset they own, period, for a family. So I'm a little bit uncomfortable if that initial period is much longer than what the appeal period is. So I'm a little concerned that I'm more apt to lean towards Bill Close's suggested language, which is really restrictive in case of fraud. We can go back, but I see, there may be, you realize very shortly after issuing a permit, somebody may point an error out to you. But there's got to be, 4 years or even 2 years is way too long of a period. That's why I was asking about what is the initial approval period, so.
So just to clarify, and we certainly can make that revision. Again, we're recommending a 5th reading, so we're happy to do that. And it may be that the board wants to recommend that we do it within the appeal period, so the decision is still active. I did want to point out that currently the code does give us that authority. So again, we're happy to make the revisions according to what the board wants to see here, but the language that's being proposed is more restrictive, so it's not like we were trying to open something up. But again, I think I understand very much what the board is saying. It is something that's been in the code. It's not something that we've used except for in a couple of limited circumstances, but again, the board may want to consider revising that language to either to make it only in the case of fraud, as you were suggesting, as Mr. Close did, or giving us the authority to do it within the appeal period.
Yeah, the only time I'm aware that you guys have revoked something that I know about was actually during still the appeal period, and it was a case where the applicant had actually fraudulently claimed that they had a Measure 49, approval when it wasn't sold with the land, and we found evidence of that. So I can't, I'm having trouble, with the idea of years later we might, or even 6 months later, which you can invest a lot of money in 6 months, having that be such an open-ended thing where it's our error. And I'm thinking about even, we had something come before us where somebody wanted to subdivide a piece of land based on underlying deed lines and all that. And it really went back to where we made an error back in 2003, but we couldn't go back necessarily and say that error in 2003 completely goes away. We're just not going to add to it by declaring that you have another parcel that we don't think you should have. A recent land use case we heard. But we didn't go back and, rescind a previous approval. So I'm just, I would like to see something tighter in that language personally, but I don't know if that's shared by the entire board.
If I might, there's probably another alternative we could craft, and this, just so the board has its options in front of it. We could alter the language to adopt sort of the Bill Close recommendation that it only be applicable in cases of fraud. The other is fraud or within the appeal timeline. And then a third might be in cases of fraud or the lesser of the appeal timeline or when some sort of material investment toward the development has been made. That's a looser standard and obviously discretionary and will be subject to its own appeal potentially, but that provides something beyond, I don't even know what the appeal period is anymore, I can't remember offhand, but it's not very long. What's it? Yes, 12 days,
Yes, that's
which
really.
isn't a very long time to discover the error, but if someone gets an erroneous approval, does nothing with the property for 6 months, and then suddenly this comes to pass, then the county may still want the authority to take that back.
I think the material investment might actually be better than the appeal period in some ways, because I think that, one, you could argue if somebody tries to make a material investment before the appeals period's over, you might be able to, I would say whichever's longer out of those two.
Yeah.
Material investment or appeal period, whether they've made it, if you're still in the appeal period, we should be able to revoke at that point because they could have been appealed for the error that we made. So that's, making an investment before the appeal period's over is their risk. But once the appeal period's over and they've got an approved action by the county, it's difficult. But then, it's kind of like we also have this standard where you have to make material investments to vest your right in an approval a lot of times to get extensions. And we've had arguments before us about that. I think we could, this is sort of the reverse side of that, where we can actually pull your approval if you haven't made that investment if we find an error. That makes me feel a lot more comfortable because it's really, my concern is about somebody investing a significant amount of their resources, and then us figuring out we made a mistake. And they've got, tens of thousands, if not hundreds of thousands of dollars invested. And we're trying to pull that back and declare their permits illegal. So I think that might be better language. It would give us more option, cases, in a case of fraud, I don't care. But I just concerned, so I guess the appeal period or a substantial investment, and then that's going to be discretionary, I'm sure, and appealable, which I think it should be, because it's the same issue about when somebody's, objecting to somebody's extension of a land use approval. We've had those objections based on arguments that they hadn't made a substantial investment, or they hadn't carried into the next phase. I think we had a school come before us about arguing that whole issue recently, so, or not too far in the past. So I think that makes a whole lot of sense. I don't know if we can, the unfortunate thing is I don't know if we can do that here and now with language and avoid a seventh reading. But that's kind of, I'll look to staff to see if they think they can craft that well enough to have us read it today.
Well, if I may, one thing I would like to point out is in your, the hearing packet for the first reading and second reading and public hearing, the March 13th public hearing, it's on page 1,108 of the PDF, but it's the Planning Commission early on in the process had recommended some language similar to what you just recommended. So they had recommended that a decision issued in error could be revoked only when it's during the time period that the approval is still valid, prior to finalization of all conditions of approval, and prior to the expenditure of a substantial financial investment in the physical development of the property.
Sounds pretty
They
close.
had some concerns
The only that leaves out
about.
is fraud, but we don't, I think we could probably push the fraud issue, even if it's not in the code, a revocation.
And there is also a provision that says that if the approval was secured with false or misleading
Okay, good,
information,
good.
so that should be
Good.
covered.
That covers fraud then. Yeah. Okay, well, then if the motion were made today for the fourth reading to include the language the Planning Commission recommended on revocation, that would avoid having to go to a sixth reading.
Yeah. What are we on,
Fourth.
4?
We're on four.
Yeah,
I'm trying to avoid going to six,
as long as,
following that.
Yeah.
Record of.
yeah, as long as we essentially read in or the record contains a verbatim language that we can refer to, yeah, that's fine.
Well, it sounds like the record on page 1,000 what?
1,108.
1,108 has the exact language we would like to adopt under revocation.
Yeah.
And then, of course, we'll also have to note the changes to the appeal filing procedures in the motion as well. We already have written into what was prepared and notice for today, the House Bill 424 changes. So the motion just specifically needs to note anything on the revocation and the appeals. And of course, setting the fifth reading and deliberations for June 19th. And the 1 week open record.
I see Commissioner like in writing.
Yeah. Yeah, I'm trying, so the motion needs to reference the revocation language as recommended by the Planning Commission on page 1,108 of the record. The language submitted today by staff on the appeals filing procedures. Holding the record open for 1 week, written record, I should say, open for 1 week, and setting the fifth reading deliberations for June 19th.
That covers it.
Before we get there, I'll ask if there's any other discussion or questions for staff. before I ask for a motion.
There's that one thing on page 1,127.
Yeah, thanks a lot. All right.
I'm watching staff whisper, so I want to make sure that they're all comfortable with that before I ask for a motion.
Yes, I think we've got everything in the record before you now, so it will constitute a reading as long as the board approves the changes we've talked about, you referred to.
Great.
And I'll note just for the record that the one difference in the language that I threw out was I used the word material expenditure. The Planning Commission used the word substantial in terms of how much money they spent. Those are loose discretionary terms. The board may have its own idea of what that means. If someone spends $1,000 to hire an expert to come out and look at the property, is that substantial or not?
What's the language we use when we're extending a land use decision? What's the language we use to the developer has to show somehow or another progress or substantial progress or material? I don't think they say material investment. I think they say substantial there. It'd be nice if we kind of mirror that language at least a little bit, because it's kind of the mirror image to that. How do you hold on to a permit? This is how you prevent having one yanked, I guess, it should be similar language.
Some of the vested rights.
Yeah.
There's a lot of vested right case law that talks about what it takes to vest your right, how much expenditure.
And this is kind of a reverse of a vested right in some way, but it's kind of like when can we not take away an approval? How much investment is there that gives you that?
So it doesn't look like we have language for the extension.
Yeah.
It isn't based on having to have made any substantial investments.
I'm comfortable with substantial versus material. I think it's either one's a subjective.
Yeah, it's going to be a judgment call made by the board or the hearings officer or just director whenever it happens, and it will potentially be a subject of appeal, but there's no way around that really when you've got a discretionary decision made. So
Yeah, part of due process. And I think this is an issue of due process. That's what I was trying to avoid, not having some due process for somebody where we make the error. So, are you ready?
Feel free to correct as we move along. So I'm looking at Mr. Clark on this one, so feel free to correct. So, Mr. Chair, I'd like to move the fourth reading and setting this fifth reading on Ordinance 1802, in the matter of amending Lane Code, Chapter 14, to add, revise, and delete definitions and provisions to modernize and update the entire chapter, and amending Lane Code Chapters 10, 13, and 16 to update references, definitions, and provisions for consistently with Lane Code Chapter 14, and would like to include the following: the language of the Planning Commission revocation listed on page 1,108. So far, all right, and which also includes the proposed revisions as submitted by staff. Do you want it more specific
On the appeals.
on the appeals?
Sorry, with regards to the Planning Commission's recommended language, you may add that was the March 13th packet.
March 13th packet, and then with leaving the record open for 1 week and beginning what day to what day?
Through next Tuesday at 4 p.m. would be great.
Perfect. So next Tuesday, and that is the
29.
May 29th at 4 p.m. And did I mention that we're setting the 5th for June 19th at 1:30? I better make sure I state that. So does that cover it?
yes, I believe so.
Mr. Chair, I'm looking at you.
I think you covered it.
Okay.
Second. Does that
I
cover
didn't think I
that?
got that one.
So it's been moved by Commissioner Lycan and seconded by Commissioner Farr to approve the fourth reading of Ordinance 1802, wrapping in the changes to the revocation language proposed by the Planning Commission in page 1,108 of the May, what was it, the
May
March
13th.
13th.
March 13th packet, and including the changes proposed by staff of the appeals language they get provided today,
Appeals language.
and setting the fifth reading and deliberations for June 19th, 1:30. Any discussion to the motion? Seeing and hearing none, I'll call for the vote. All those in favor, please say aye.
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 Any opposed? Motion passes unanimously.
Thank you.
You're welcome. So that brings us to item 13C, which is a first reading and setting the second reading and public hearing for Ordinance 1360 in the matter of amending the Rural Comprehensive Plan to redesignate land from Forest F land to non-resource NRES land and rezone that land from impacted forest F2 RCP land to rural residential land zone RR5 slash non-resource RCP for a 131.55 acre property along with the site review suffix and adopting savings and severability clauses. File number 509 PA 1505722. Applicant is Gimple Hill LLC, and we have Deanna Wright here to
And,
present.
Mr. Chair, I think I should ask Ms. Wright if Mr. Malone was involved in this matter.
I don't believe so.
Okay, then I won't put on the record my disclosure involving Mr. Malone.
So today, we're just here to request the first reading and move to set the second reading and hearing for June 5th. At that hearing, I will have a verbal staff report to present to you. The packet is available online on the agenda web. It is fairly large. So if you have any questions about the packet, I can answer them right now.
Any questions for staff? And I'll entertain a motion to approve the first reading and set the second reading and public hearing.
It is slow.
Could we make this a little more complicated? This is,
This one's not, this, yeah, anyway. Mr. Chair, I'd like to move the first reading and set the second reading and public hearing in Ordinance 1360. Am I right? Yeah, in the matter of amending the Rural Comprehensive Plan to redesignate land from forest land to non-resource land and rezone that land from impacted forest F2 land to rural residential lands, zone RR5 and non-resource RCP for 131.55 acre property along with a site review suffix and adopting savings and severability clauses, and we'll set that, the second reading on June 5th, 2018, 1:30 p.m.
In public hearing.
And public hearing, yeah, mention that first.
second.
So it's been moved by Commissioner Likens, seconded by Commissioner Farr. Any discussion to the motion? Seeing and hearing none, I'll call for the vote. All those in favor, please say aye.
Aye.
Any opposed? Motion passes unanimously. Thank you.
Thank you, Commissioner.
Thank you.
Brings us to our last Public Works item. Order 1805-2207 in the matter of amending Chapter 60 of Lane Manual and to adjust existing waste management fees effective July 1, 2018. And we have Jeff Orlandini. Did I do that well?
Yeah.
Interim Waste Management Director and, or Waste Management Department Manager. I guess I always get the directors, managers mixed up. I'll turn it over to you.
Thank you, Chair Bozovich, and good afternoon, Board. I'd like to take this opportunity before Jeff goes on with the item to introduce Jeff Orlandini to you. He's been working in the Waste Management Division for several years and is one of our two outstanding fee collection supervisors, and he's graciously backfilled me as the division manager since the beginning of the year. So with that, I'll let Jeff introduce the item. Thank you.
Okay, thank you again for having me today. And Dan will be here to coach me along if I make any mistakes first time here. So, as you're probably aware, in 2014, we implemented a large fee increase in waste management to work towards balancing our budget which included setting aside money for closure, post-closure costs for the Short Mountain landfill, as well as future cell development. So that large fee increase, along with fee increases in 2016 and 17, and our own improved operational efficiencies, allowed us to balance the budget in 2017. At that time, the board had recommended proposing smaller annual increases based on the consumer price index instead of waiting upwards of 7+ years to do very large increases. So we're here today because the budget direction CPI for fiscal year 2019 is 2.6%, which is the amount we're requesting to raise our fees. The actual CPI for the last calendar year of 2017 was 4.9%, but we feel we can maintain a balanced budget with the budget direction CPI, so with the lower of those two, so not making such a large percentage increase. And we believe this will bring us into alignment with budgeting across the county. We're not proposing an increase on our volume-based fees, mainly due to cash handling issues. So at our rural sites, we deal in quarters and no change smaller than that. So to do very small increases would cause a big cash handling issue. And so we usually wait till it gets to where it could be a quarter or more. And we also had our largest fee increase most recently to those volume-based fees when we shut down the Mapleton site. So that was part of those operational efficiencies. So we feel like we did a large increase just in late 2016. So we're just going to do those on our weight-based fees. This fee increase will allow us to absorb the increases in expenses that we're experiencing with operational costs. We have already proactively notified our stakeholders, i.e. the commercial haulers, that we'd be proposing a fee increase and the percentage we'd be proposing so that they could adjust accordingly due to the timing of negotiations they have with their municipalities. So they've been informed of this and know that we're proposing it. And then we'll inform them as soon as it's official so they know it'll happen. And so with that, I can answer any questions you may have.
Any questions? Well, thank you and welcome to the hot seat, Jeff.
Thank you very much.
I don't have any questions, but I do want to note that this is, great follow-up to some strategic decisions we made in the past, where we had to make that big jump in fees, which caused a lot of consternation when we did it, but we understood why we had to do it because the past boards hadn't adjusted and we needed to get the money set aside for the next cell and maintain our closure reserves there. This is just, really great follow-on to that, where we're following the direction that we made then, which is let's do stair steps instead of giant leaps. That's fine for Neil Armstrong, but not good for government policy. So I really appreciate that follow-up. It's something, way back in my days as a Lane Community College board member, one of the first things I had to do was make a major raise in tuition because the previous boards had failed to kind of keep up with costs. And when there was a sudden decrease in revenue, it put out of balance their budget, and we had to make this huge change. And one of the things we implemented then was tying tuition to CPI and having gradual increase at LCC. So similar policy, and it's good policy because I think it prevents those sudden jumps and allows, folks that are on fixed incomes and all that stuff to have a more gradual change in their expenses rather than that all at once. And how do I handle that? Because they're also getting CPI-based increases sometimes in whatever source of income they have. So works well. So thank you for that, for keeping with the strategic plan here. Any other? Commissioner Lykin?
I have no questions, just we're ready for a motion, Mr. Chair.
I think so.
All right, so Mr. Chair, I'd like to move approval order 1805-2207 in the matter of amending Chapter 60 of the Lane Manual, LM 60.875, to adjust existing waste management fees effective July 1st, 2018.
Second.
Been moved by Commissioner Lykin, seconded by Commissioner Farr to approve Order 1805-2207. Any discussion to the motion? Seeing and hearing none, all those in favor, please say aye. Aye. Any opposed? The motion passes unanimously. Thank you.
Thank you.
So that brings us down to review of assignments, but I want to briefly jump to other business. And maybe this really jumps back to Commissioner's business a little bit, but something that Commissioner Sorensen brought up made me think about a question that maybe the board should be asking itself. Lane Charter, Section 11, specifically says that while serving as a member of the Board of County Commissioners shall devote full time to the office. So having items come up as potential conflicts of interest due to outside employment are troubling to me. And I kind of want to, maybe we could have a little discussion and maybe have county council weigh in. Because I also have, my wife has a business and I have to get involved in that now and then. So I don't know what percentage is considered full-time and whether that's been addressed in the past. Maybe as the longest-serving commissioner, you may know that.
Yes, it was addressed during the time of Commissioner Bill Rogers, who ran his Filbert farm out of his commissioner's office. County council did restrict that, but he had a big farm that he was running, and when he was elected to the board. So questions were asked, well, is that if he's devoting full time to being county commissioner and he's devoting any time to anything else, is he devoting full time? And the answer at that time was he said he was working full-time, so therefore he was working full-time. It came up later when Commissioner Jack Roberts faced almost the identical situation I face, where Jack had been a lawyer and had a tax practice and a very unique practice, and he was asked by people to work with him on a part-time basis. And legal counsel was asked, okay, well, if he's working part-time, but he's full-time, can you be full-time and part-time? And the answer was yes, that part-time is defined by the commissioner and full-time is defined by the commissioner until such time as we make further definitions of what is full-time or part-time. So that's the way it's been, my understanding, since. But like you, I'm concerned about, well, commissioners don't get vacation time officially. At least it's not recorded on our pay. And so we are treated differently. We're clearly treated differently. So, but that's the way you deal with something like, maybe in your case, where you and your wife own a business. She does 90% of the work. You do a small percentage of the work. And you then have you're working part-time in the business.
Yeah. And I've always looked at it as I devote way more than 40 hours to being a commissioner.
Yeah, I think that's part of the reason why.
May get maybe a couple hours a week where I assist her with the business. So that's kind of, I've always justified it as I'm more than full-time as a commissioner. Commissioner Barr.
You bring up a really good question, Commissioner Bozovich, and your definition, you work 40 hours a week. There are different definitions for different companies. 32 hours a week sometimes is considered full-time in different companies, but we are actually paid for 40 hours a week on an hourly basis. If you look at your pay stub, it is a 40-hour week based on the hours that you work and the hourly rate. So that's, I'd like to, Mr. Mokroniski, I'd like to get more clarification on that to make sure that we're not just interpreting something that seems reasonable, but really, in fact, would not be. So maybe having Mr. Dingell take a look at it just to define it.
Yeah, I've been operating this way for almost 8 years, and it'd be nice to know that I'm operating within.
Well, and the other issue is that if commissioners are not being compensated for the time we spend, then are we really following a federal or state law that says that people who work, 45 hours a week are paid for 45 hours a week and not paid for 40 hours a week.
Yeah.
And similarly, commissioners that work 30 hours in any given week, but they're paid for 40 hours in any given week. So, but I think most people that have done this job will realize that they're never going to really ever work a 40-hour week. They're just never going to do it.
Yeah, it is, you're never not a commissioner. It's the way I've always described it to people. I can't go to the grocery store without being asked a question somewhere in the produce section or something, yeah. So, yeah, it'd be just kind of good to get a little bit of definition around that from legal counsel. Just the issue brought to mind that, so just now that we've kind of gotten that discussion out of the way, is there any other business before we go to review of assignments? So review of assignments, Steve?
Just have that one that you talked about, requesting that legal counsel provide clarification about the, any conflicts of interest for commissioners with other employment.
Great, thank you. Yeah, I know I've turned down lots of offers to do engineering work when I first got elected. So, with that, if there's no other business for the board, we are adjourned. See you guys for Homes for Good.